PDC speaker, and he focuses his practice primarily on two concentrations, civil litigation and sports and entertainment law. He has tried more than 50 circuit court cases to verdict and represented members of the sports and entertainment community worldwide. He has been and remains a guest lecturer on civil litigation and sports and entertainment law practices, as well as sports journalism. He is admitted to practice in Virginia state and federal courts, including the Fourth Circuit Court of Appeals. He was also admitted to practice before the Sixth Circuit Court of Appeals and the Supreme Court of the United States. Mr. Sievers is on brief for 2 cases argued before the Supreme Court of the United States and several cases before the Virginia Supreme Court. He has authored published opinions for the Honorable Glenn M. Williams, Senior United States District Court Judge for the Western District of Virginia. Mr. Sievers is also a freelance sports writer, and a catalog of his stories for Yahoo Sports can be found at thepostgame.com. Please welcome Mr. Sievers.
Thank you. And I'm going to confess to you that I have a mole in the audience in the back. I'm going to embarrass him. Todd Gaynor, who's a former law partner of mine who practices here in the Virginia Beach, Norfolk area. So if any of you are practicing in this area and want a contact, Todd would be a great guy to see afterwards, or shoot him an email at some point. He's a sharp legal mind and someone you would want to get to know. Can you all hear me without this microphone here? All right, so I appreciate the introduction. I'm just going to go a little bit deeper. Yeah, I don't want all these stories to be heard. That's right. Oh, whoops. That's right. Oh, let me get this thing right. So I guess what I'm trying to say is I didn't have Harvard knocking on my door, Yale knocking on my door, William and Mary, whoever, inviting me to their law school free of charge or in any format. So there was a new school that popped up called the McEachin School of Law in Grundy, Virginia. And I, as I said, grew up in Northern Virginia. There was no way in the world I was going to Grundy, Virginia. Certainly not without protest. But as luck would have it, that's where I went. And I tell you that story because it's the best thing that ever happened to me. And it's part of the theme that I want to talk about today, which is networking, letting things happen that appear before you, making lemonade out of lemons, if you will. And the Appalachian School of Law was what started me on the path that got me to where I am today. And was in a class of 30 people. It was in the third ever class. Now it's 100 plus per class, I believe. And here I am in law school. What is this all about? I'm learning the 1L experience like you all did, and did well enough, I suppose, amongst the 30 that I was with, that I was able to get involved in student government and meet some of the people in the community, and took real advantage of those opportunities. So my second year, in those days, if you wanted to apply for a federal clerkship, you had to do it as soon as you started your second year. The career services lady came to me and said, "Hey, we have a judge over in Abingdon who's looking for some federal clerks. Are you interested?" I said, "Well, the first thing I need to know is what is a federal clerkship?" And she told me, and I said, "Sure, I'll apply. But I'm not going to beat the Harvard guys, the UVA guys, the William & Mary guys." She said, "That's fine. Just give them your name, give them your information." So I did. And as luck would have it, this particular judge, although he did get a million applications, really wanted to take an interest in our school, and so he invited some of us to interview for the post. So I figured out, or I said to myself, what am I going to do in order to stick out amongst the UVAs, the Yales, the Harvards? And this is Abingdon, Virginia, okay? So this is seersucker country is what I'll call it. And I found out that the judge was partial to seersucker suits and also the Cincinnati Reds. So when it was my turn to interview, I figured, what have I got to lose? So I walk in the room, and the judge says, "Have a seat." And this is, mind you, this is a 78-year-old man who's been on the bench longer than I was alive. He's seen and heard it all. And he says, "Have a seat." And I said, "Before I do that, I have a question for you." And he says, "What's that?" And I said, and by the way, I was wearing a seersucker suit. I said, "I'm a Mets fan. I'm not exactly sure how you and I are going to get along when you hire me." And for the next hour, we talked baseball, and I got the job. So the point that I want to make here today, aside from the real topic maybe, is that things like that are just as important as your knowledge. I mean, I certainly wasn't the smartest candidate that came through that door, but I guess I got lucky and figured out how to connect with someone, and I think that's almost as important, if not more important, than your skill set that you have. Obviously, you need to be competent, and I trust that everyone is. But beyond that, you have to be able to separate yourself or rise to the top or distinguish yourself in some way. So I had my federal clerkship and then took a job in Richmond with the Attorney General's office as an assistant attorney general, and that's sort of a flashy title. But what I was able to do was work for represent several agencies, and you heard in the introduction I was on brief for a couple Supreme Court cases, U.S. You have to be out of law school 5 years in order to argue in front of the U.S. Supreme Court. And make no mistake, I was never slated to argue these cases before the U.S. Supreme Court. But it was neat that I was able to have my name attached to it, to actually participate in the preparation of the attorney who did the arguing and go that day and hear the arguments and see the live gunfire, if you will. So, again, an opportunity that sort of fell into my lap, but then you scan the landscape and you see what you can do to make it that much better. I was with the Attorney General's office for about 3.5 years, and then I decided I wanted to see what the private sector is all about. And it was a changing of the guard, if you will. It was an election year, so it made sense to get out then. For those of you who may be working for the state or are interested in that, I commend you. I think it's a great place to work. My only piece of advice might be, if you want to do it, you either do it for the long haul or you do it for a short period of time, because the back end is great. The pension and the retirement plan is there, but if you get caught in the middle, it may not be the best place to be. But it's a great place to work for new lawyers, because they will give you the experience, the courtroom experience that you may be seeking if that's what you're interested in. They will let you in on your own and see what it's like to operate in a courtroom. So I decided to jump into the private sector, where I did what's called insurance defense work. For those of you that don't know what that is, basically it's representing folks in automobile accidents, or maybe someone's house burns down and there's a dispute about what caused it. You're defending the insurance companies or the drivers of the cars in the courtroom. So that got me, as you heard, a lot of trial experience. In fact, my number is now over 60 jury trials to verdict, which is sort of amazing. I had one 2 days ago, and I have 3 next week. So it's rapid fire, but you can do it. And I want to tell you some of the ways here today on how you can do it. And I will touch at some points on the sports law stuff, but that's not the focus of my topic here today. But I will weave some of that in. So you all have got the outline, I presume, in front of you. And I encourage you, please, ask questions. That's why I'm here. This outline is good for about 30 minutes. You guys are the other 30 minutes. So anything and everything you want to ask me, please. So the first thing I want to start with is sort of client development. And I've got some quirky, silly little sayings I plugged in here just to exaggerate the point. The first one is, it's not what you know, it's almost always who you know. And I've touched on this a little bit, but every job I've had professionally, with the exception of the first one, has been because I've known the hiring person. I mean, it's not to say that you can't go in somewhere and shine not knowing the landscape or the people involved, but it really does make a big difference if you know the people that are interviewing you, or know something about them, or know someone who knows the person who's doing the hiring. Leave no stone unturned. Figure out where you're going in if you're looking for jobs or for clients before you go in and make the pitch. But you got to let people know who you are and what you're doing, or they're going to pass you right by. I mean, you've gone to law school, you've sweated it out for 3 years. Be proud of that. Let the people that are in your life or that you know what you're doing so they can help you. The next one, never propose marriage after the first date. It's kind of a silly one, obviously, but my point is get to know people over time. There's no rush in some regards for this. And plus, you don't know what's going to happen 5 years later or 3 years later. You could come full circle on things. Todd and I used to work together. Hadn't seen him in a while. He came today. It's helpful because now I can direct him to some of you if that works. He and I can circle back and say, hey, what can we do together? So meet people, learn who they are, remember them, but just don't ask them to marry you the first day. What sort of ties into the next one, there is such a thing as love at first sight. If you know what you want to do, I say go for it. But you don't have to panic. You don't have to know what you want to do. There's plenty of time. And some of you may be entrenched where you are, and that's great. But if you're sort of feeling it out like I was, be open to the opportunities that may or may not come your way. Always be on the lookout. Hear your friends. What are they doing? Do they like where they're working? Again, if you're someone who's interested in sort of trying different things out before you land in one particular spot. Business and pleasure can and sometimes do mix. I strongly believe in this. And the next line ties in. Country club memberships are more than just plaid jackets. There's a group in Richmond, and there may be one here, called the River City Sports and Social Club. I don't know if any of y'all are familiar with this, but a buddy of mine actually started this about 11 years ago. It's dodgeball, kickball, flag football. There are 300 teams, I think, that play in this group. One of them is the Young Lawyers group of Richmond. I mean, there's other law firms that have teams. I think my point is twofold. You go out with maybe if you're on a committee and you want to get to know your committee members better, you join this team, you go out and you get to know them. But also, all of these people are now your potential clients, right? Or the people they know are your potential clients. So it's infinite. So the point is, if you guys are 80s products and you remember Laszlo, don't stay in the basement, okay? Get out of the basement and meet people and join the country club, whatever that may mean to you. And when you do, let people know who you are and what you do. Otherwise, again, you just wasted that hard work that you've put into 3 years of law school. This next one is a big one to me. When you meet someone that's new, they're not a stranger. In other words, you're going to have something in common with everybody you meet. Figure out what that is and bank it. You're either lawyers. What kind of law do you do? You're interested in sports. What kind of sports do you like? You both grew up in Richmond. Where did you grow up? Find that common thread and then just build on it. And again, it may lead to nothing, but it won't lead to anything if you don't at least try. So, and a lot of these things are not new. I didn't come up with these. You all have heard these. But just remember these things now that you're out in the legal community getting started. And I guess I think it's a fair question to ask. Everyone here has been out for, what, less than 10 years? Has anyone been out here for more than 5? You've been out more than 5? Okay. All right. So most of you are getting fairly started in all of this. And so it's just important to scan the landscape. Remember everything that was behind you in law school. In other words, don't forget your friends. Don't forget where you grew up. Don't forget your interests. But bring all those to the table now that you're a lawyer, and they will help you with client development. This next one, here I am doing it. If you're asked to speak before an audience, do it. No matter what it is. Obviously, if it's a group you fundamentally disagree with, don't. But my point is, I now have the opportunity to meet you folks. Maybe you can help me. Maybe I can help you. Maybe it's tomorrow. Maybe it's a few years from now. But we've made these connections. And I'll leave here and people will say, that guy was terrible. Don't call him. Or they'll say, he was great. Maybe we can call him and see what he can do for us. But if you don't come to these groups, you'll never get to meet new people. It's just another opportunity to introduce yourself, your firm, what you're doing, and more importantly, to meet a new subset of people that you never would have crossed paths with. And again, more clients. And that's sort of why we're here, to discuss client development in that sense. Why put off till tomorrow what you can do today? Obviously, that means that in this fast-paced world, you don't want to sit on things. And I said earlier, you don't propose after the first date. But my point is, follow up with you meet somebody new, send them an email. Hey, nice to meet you. Appreciate the lunch or the coffee or the conversation, whatever it may be. Let's keep in touch. And then follow up with them a few months later if you think there's something there that you can do. A lot of the clients that I get, we can help, but not all of them. So it's always good to say, hey, Mr. Jones, I can't help you in this instance, but I know someone who can. Because you're not losing that client. You're helping them find their way through this troubled spot, whatever it may be. So it's always better if you can shepherd them to someone rather than to say, I don't know what to do, you better get online and look yourself. So just bear that in mind. If you can't help them now, find someone who can. And I think your clients will stay with you then as a result. Have your business card handy. And I put in there in parentheses, no, this is not ambulance chasing. Always have them in your pocket. If you do litigation, the clerks are going to ask you for them. The judges are going to ask you for them. Inevitably, you'll be in the hallway and someone will come up to you and say, hey, you're dressed nice. Are you a lawyer? Yes, I am. Here's my card. And again, it's a good thing to have in your pocket for folks when you meet them. That way they can shoot you an email or you can shoot them an email. Whatever the case may be, it's not a seedy practice by any means. I think everyone should do it. Volunteer in your community. Obviously, we're talking about civic organizations, churches, if that's what you do. Whatever it is, it's another layer of potential clients. And you hate to say, I don't go to church to get clients, and you don't. But if you're in the business of helping people, which you are, you're just making yourself available to these people, and they'll be appreciative of it if they ever do need your help. I mean, I tell most of my clients, I hope I never see you again. And I don't mean on the street, but because if they've had to come see me, it's not a good time for them. We help them as best we can, but if they don't, I want them to recommend people to us who need help, but I don't want them to come back for the reasons that we typically see them. But it's comforting when you're in a civic group, bowling team, whatever it is, for them to know that they can trust you with a situation if it arises. So I think that's very important to volunteer in the community in that way, your kid's school, whatever it is. And a way to do that, I mean, every school that I've ever been to has a golf tournament at some point. If you're in a position to be a sponsor, a whole sponsor, whatever it is, it lets people know that you're out there. And then they can come to you. I didn't know you did this. I mean, I have so many of my friends that used to come to me and say, I didn't know you did that. And so that's why I stress also in part, backing up a little bit, tell people what you do. Take pride in that. Not only because you've earned it, but because this is all about keeping the lights on, which I understand flickered a little bit earlier, right? But if you're interested in keeping the lights on, you need to let people know what you do. It's just that simple. The next one, social media. I think that's a scary thing for a lot of people, a very neat thing for others. I'm a huge fan of social media, and I may go off on a little bit of a tangent here, but the reason why is this. I don't go on to Twitter or onto my blog and say, hey, I'm a lawyer who helps people in car accidents. If you need me, come and see me. But I just make connections. I meet people. I talk to them, and then they say, well, what do you do? And then it's part of a natural conversation. You're missing opportunities if you're not out there. Now, I caution you, obviously, you have to be wise about how you use it. And I have a blog, Sports Esquire at blogspot.com. I wrote an article on there about using LinkedIn, Twitter, and blogging as 3 free ways to get your name out there and to meet people. Listen, you have an opportunity to meet people in California, in Germany, whatever it is, as a result of social media. You never would have met these people. And here's the tangent, here's the sports law piece. I enjoy sports a lot. I hate to read. I know that sounds funny since I went to law school. So most people would logically say, well, then what are you doing writing articles? Well, I do enjoy writing. So I started this blog. I was on Twitter. I bumped into someone who was an editor at Yahoo Sports blog called The Postgame. Hey, would you like to write a piece? Yes, please. Next thing I know, I'm connected with people in California who saw my article, who want to do some business in Virginia. So now I write regularly for Yahoo Sports, and I do it for fun. But what happens is I'll write about an athlete or a topic or a subject, and then they say, we've had this experience writing this story together. I've got a little bit of legal trouble. Can you help me with it? Or a friend of mine has a little bit of legal trouble. Do you know what we can do about it? So I think the point is you never know when and where someone's going to come from that wants your help or your advice. It's also fun to do it. So whatever passion you have, whether it's Pinterest or whatever it is, in the social media world, do it. Don't be afraid to do it. You have to do it. Just make sure that you, of course, don't set off any tripwires with the bar or anything like that. But for the most part, if you're just out there being yourself, discussing your interests, it'll all come naturally and it'll work itself out. So social media is a big one. In the real world, if you will, is court-appointed lists. I don't know if anybody here does criminal or civil, but if you do either of those, they both offer opportunities to get your name on a list. And it's not going to get you your first Mercedes by any means, but it's a great place to do three things actually. Get courtroom experience, fast and furious, develop a client base, and to build a rapport with the judges and the clerks. And I'm going to talk to you about how important that is if you are a courtroom attorney or interested in a courtroom practice. So I recommend highly that you get on those lists, if at all possible, if that is your field of interest, the criminal defense list or the guardian ad litem list. And the guardian ad litem list, primarily, well, you can do it for two things. One, in the juvenile setting, you need to represent a juvenile who is free from the pressures, if you will, of his parents or guardians. But also in the world I operate in, if a kid has been injured in a motor vehicle accident, the court sometimes likes to see another lawyer step in and shepherd the child through the process free from prejudice. It's a great way to do some good legal work. It's not that stressful, and you'll get to meet the judges, and they appreciate the guardian ad litems probably more than they appreciate any other lawyer in their courtroom, because it's someone who is doing something with their heart in the right place, and the judges see that. I got ahead of myself earlier, but the next one is tell your friends and colleagues what you're doing. Again, hey, I'm Rob Sievers. I work at McEachin & G. We're a Richmond-based firm. If we can help you, let us know. Or this is what I do. I mean, a lot of people, I'm a doctor. Well, what kind of doctor are you? I'm a heart surgeon. I'm an orthopedic surgeon. I'm a pediatrician. I can't tell you how many people say, well, you're a lawyer. I guess that means you do everything, right? I mean, it's just not true. I mean, you could be an appellate lawyer. You could be a business lawyer. You can be a personal injury lawyer. So you need to tell these people what you're doing. Otherwise, you've wasted an opportunity to let people know what you're doing and, again, develop a potential client base. Let your reputation precede you in a positive way. Obviously, if you treat people with respect and fairly and honestly, and you do a good job, even if they're your adversary, they're going to tell people, hey, you might want to go talk to this person if I can't help you, because they did a really nice job in the courtroom. They were respectful, things of that nature. So, and I will tell you, in Richmond, it's a very good bar. By and large, the people there are very civil, very collegial. But there are 3 or 4 names in the civil arena and maybe in the criminal arena that if you say them, you're going to see what the reaction is. And you don't want to be one of those 3 or 4 people. It's just not a good place to be. I'm going to move on to another topic. So before I do that, does anybody have any questions about client development? Want to share an experience? Have any thoughts and any ideas? That's a great question. That's a great question. And there may be several, to be quite honest with you, but tell your friends and colleagues what you're doing isn't the most damning of the ones, but it's one that I learned, that it took me the longest to learn. Again, and I've said this a number of times, if no one knows what you're doing, that big case might go right on by. And if you're like me, you hate to you don't want to use your friends as professional pawns. You want to have friends and you want to help people when they need their help. But at the same time, one of your friends could be in need, and they don't know that you can help them. So for me, it's that. That's at least, I'm sure there are several, but that's the one that I would highlight first. So that hinges greatly upon where you're working, okay? And I've been fortunate enough in the private sector to work for great firms that allow me and everyone else in the building to go out and do what they need to do. Now, part of that is quite, for obvious reasons, if you're a firm that needs to market, like most of them do, they want you out of the building. There are some phrases that a bad day at work is a day when you're behind the desk, because that means you're not out being seen, being heard, in some instances billing, right? If you're on the side of the coin where billing is important. So to answer your question, if you have a group of folks that will allow you the freedom to do what you need to do, the balance, I think, is pretty easy, because you'll know ahead of time where you want to go and how you want to operate. For instances like this, obviously it's great for everyone at our firm for me to come here and introduce myself, and you get enough lead time that you don't have to sort of shuffle the deck to get here. But I would say if you're interested in that and you're somewhere where they're older school and they don't think that personal appearances and advertising are a good thing, it's going to be some work for you. You're going to have to pick some good events to go to and show them that it had value. And that brings me back to the social media component. There's no cost to that. So if you can show your superiors or your colleagues that I'm doing these things at no charge to you, but they're demonstrating a return, then you're going to be able to build on that. And the other part of that is I hope they understand that you're going to fail in some of these attempts. I mean, we all do. I mean, you're going to have a great idea that just doesn't work out. So you're going to have to beg for some forgiveness, ask for some leeway. But the bottom line is the issue, so you got to get your work product done first, obviously. But if you can convince them and convince yourself that an hour a week or whatever it is, I mean, sometimes we'll go to all-day events on a Saturday, which, of course, then if you're at home and have a wife and kid, you have to clear that first. But from a business perspective, I don't think it's that hard as long as the people you work with understand it. Does that help? So I guess I'm old enough that I didn't have to have that problem. And I say I'm a big social media guy. I don't have a Facebook account. I never have. I have a Twitter account that I use religiously. I guess obviously I'm very careful not to put something on there that quote unquote could get me in trouble. But and if it's a picture, it's a picture of my kid, which nobody's really gonna harp on too bad. But you do have to be careful what you say. I mean, I use Twitter mostly for my sports stuff. So it's, hey, read this neat article that a buddy of mine wrote, or it's self-promotion. I mean, I should say this. You cannot be bashful in this industry if you want to do something. With social media shrinking the world, there's a million people out there that can do what you do, whereas 10 years ago, it was only the people in the city that you lived. So, again, without direct solicitation of clients, which is inappropriate, things like that, I mean, I use Twitter to share my sports articles. And it's an indirect, like, they'll contact me, then we'll shoot an email back and forth, then we'll pick up the phone. I mean, I'm working on a CLE presentation with a public relations manager that I met in California on Twitter, right? So then it's, we have clients, and you just have these conversations off social media and figure out if it can work for you. There's a lot of dead ends, and to your point, you got to do a lot of things that may not result in any direct profit. But I myself, I'm fortunate that I wasn't in college during the Facebook era, so I don't have to hide or bury anything. And obviously there was a huge case that you all might be aware of in Virginia recently where Facebook came into play and some lawyers got in trouble, and it was a big deal. So obviously if you're dealing with cases where social media is involved, you do have to be mindful of that, and you do have to get those records, and you do have to turn them over to the other side. The next thing I'm going to move into, which is a sort of a passion of mine, is alternative dispute resolution. And in my world, okay, most of the cases I handle are in a personal injury context. And what that means is we are preparing for trial, but working towards settlement. And this applies, I think, across the board to whatever kind of litigation you're in. One bump in the road is alternative dispute resolution. And what I mean by that is if you have an opportunity to control your case, and this is what we tell our clients, take it. As good as our judicial system is, those 7 people try as hard as they can. That's all right. Those 7 people in the jury try as hard as they can to do their job. It's in their hands if they get the case. So I always tell my clients, if we can't settle this thing between the attorneys, if it makes sense, let's get involved in some alternative dispute resolution, and that's either mediation or arbitration. And obviously, mediation is not a binding arrangement. It's an attempt in good faith by both parties to resolve their differences. If you do it right, and you're successful, you're both going to leave saying, it's not what I wanted, but it's okay. That's a successful settlement, and that really is true. And most of them do work, because if you go in there in good faith, you're gonna tell your client what's wrong with their case, and the other attorney's going to do the same. And the best part about it is you're going to get a retired judge or a seasoned lawyer in the room who's not involved in this, and he can tell your clients, hey, you got a problem and you got a problem. What can we do to solve this? Because a lot of times, if a client hears it from someone that's not you or not the other attorney, they're going to believe it more. If you tell them that this is a retired judge who's been on the bench for 30 years and he knows how this could go, they will listen to them, and they will understand that they need to think long and hard about taking their case to court. So mediation is a great place to start, and there's 2 ways to do it. There's the Rule 1:19 pretrial conference to the Virginia Supreme Court. There are some jurisdictions in Virginia that require it. Some of them on the Eastern Shore, because of the way their dockets are laid out and they don't have enough judges to handle the docket, make you go through a mediation before you see their courtroom. And I'm always in favor of that. It's at no cost to you or your client. And that's a separate set of retired judges who work on that list. The second way, of course, is privately. There are a number of groups in Virginia that operate. The McEachin Group is one. Arbitration Associates is another, along with individual retired judges who just come off the bench and advertise for themselves. Yes, there is a cost for that, and some of these mediators can be expensive. You've got to look at your case and figure out if it's worth the cost. Usually you split the cost amongst the parties, but the same process unfolds. The judge comes in. And has anybody here been in a mediation? Most of you, okay. For those of you that haven't, let me just tell you what it's like. Logistically, you'll start in a large conference room, typically all the parties, and the judge will give sort of an opening statement about the process. He'll then split you up, and the judge gets his exercise that day, because if your room's on one end of the building and they're on the other, he goes back and forth, and he talks in confidence to both parties. The great part about it is he'll follow whatever set of rules you set. So if you want him to tell the other side something, he will. If you want him to keep he or she in confidence, they will. So I encourage it. In business law, whatever situation you're in, if you can resolve it outside of court, as much as I enjoy litigation, do it. The next one is arbitration. That's a little more intimidating to some people, particularly if you're in the insurance defense world. Insurance companies generally, and I used to represent insurance companies, they generally don't like arbitration. The reasons why are too many probably to list here today, but it is binding. So if you agree to an arbitration, you're going to go to the same set of people at one of these private mediation firms or another lawyer that you agree on and set the schedule. The benefit to arbitration, as I see it, is this. If you're working with someone on the other side who is collegial and agreeable, you can put a lot of the formality out of the way. And you can lessen or alleviate a lot of the rules of the court. And I think that's a good thing because it helps you get down to the issue. And I'll give you an example. I had a jury trial a few years ago where the plaintiff was on foot and he was under the influence of alcohol. And so I had a toxicologist say that the alcohol was the reason that he was out in the street and got hit by my client's vehicle. The other side, of course, made a motion to the judge that it not be allowed to be mentioned to the jury that my client was intoxicated. And I said, Judge, that's completely relevant to the case, which was this. My client was turning left. This guy was out in the street, and he walked right in front of her and got hit. And he said, well, with all due respect, there are plenty of people out here that can drive better under the influence of alcohol than they can sober. And I thought that was a very sobering comment. And I said, well, I don't understand. He said, you can't show me it's the proximate cause. It's not coming in. The reason I want to tell you that side story is because in arbitration, you could get that in if the other side agrees. Because I think it's better if the judges know everything because they understand the law. They know what they can apply and what they can ignore. So I'm in this trial trying this case, and I know that this guy's had alcohol in his system, but I have to remember not to say that. And I'm almost sort of stunned that I can't focus on my case because I have to remember what not to say. So arbitration allows you to say these things if the other side agrees without prejudice because, again, the judge can weed through it and understand that it's not relevant or it is. So I like arbitrations. Obviously, there are a lot of retired judges that won't do it. There are a few that will. If you all ever come across a situation where you want to arbitrate or mediate and you want to call me and ask me who's good at it or who I would recommend, please do. I think they're all very good at these groups. I haven't had anybody I wouldn't recommend, but binding arbitration is another way out. But suppose you can't, does anybody have any questions on arbitration or mediation? Suppose you can't arbitrate. Yeah. Yeah, so really it's an impossibility to not violate those agreements in one sense. I mean, you're in the room and you've talked about the accident as an example, and then you're in a courtroom talking about the accident. The point is if it hasn't been discovered, you can't talk about it. So if your mediation fails, you need to make sure that you get, in other words, if you learn some great secret in the mediation, send out a request for admission or an interrogatory is a way around it if the mediation fails so that you can get that information through the proper channels. Those agreements are more sort of to demonstrate that everyone's in this room with an olive branch and we're here in good faith. But you can by and large get that information through proper discovery channels at a later date if you need to. It's interesting you say that or ask that question that way because most of the time when you go into mediation, you would not be met with a smoking gun. In other words, you've already prepared the case to the point where you should know what's going to be said from both sides. Now, understanding you can't know everything and there will be surprises, but by and large, if they say something huge, you would probably start leafing through your discovery and say, wait a minute, I asked you that. Yeah, and I don't do a lot of I don't do a lot of business law, but if there's something in the contract that mandates mediation or arbitration, and you've signed it and it's not been proved to be fraudulent or something like that, then you've got to follow it. But I don't know what tripwires might be there as far as I don't know. I've just never done real estate law, so I don't know how to handle those discovery lanes. But let's say your case can't make it to, or you're not successful in mediation or arbitration. All right, now we're in court. So I just want to sort of hit on some of the things that I think have helped me through the years in both, and listen, this is focused on state court, okay? Federal court would be a completely different topic. The Eastern District is called the Rocket Docket. If you've heard that, I mean, and it lives up to its name. Federal rules of evidence apply. Federal rules of procedure apply. It is a different animal than the state court. So this, for purposes of today, we'll focus on state court. So we're talking about general district court and circuit court. The first thing I like to do, and it's hard to do this, but you got to try, is put yourself in your client's shoes. You're busy, you're running a firm, you're trying to market, but these people, I mean, this is the sick patient. This is the person whose whole life is bottled up into this one thing, and they're not going to focus on anything else until this is behind them. And oftentimes we're talking 2 or 3 years before it's behind them. They're living this nightmare. That's all they're thinking about. They're losing sleep over it. You've got to remember that for 2 reasons. Your clients are going to come in frayed on their last nerve, and they might be ready to just jump down your throat about some little thing. You got to be able to take it, and you got to be able to calm them down and yourself down. But also, if you put yourself in their shoes, it'll help you tell their story. You know, selling your case to the jury is a passion. You have to be able to do it. And you can't do it if you don't understand what they've been through. Now, I'm not telling you, obviously, to go out and get rear-ended just to see what that feels like. But my point is, understand their socioeconomic background, understand their personality, understand who they are, and how you can best work with them to solve this problem. And sometimes that means you have to sit them down and tell them, look, common sense is one thing, the application of the law is completely different, and help them understand that the 2 things don't always intersect. But my point is, understand your client, get to know them, ask them some personal questions if you think it's appropriate, figure out who they are, take this journey, if you will, with them. I think that's very helpful. Understand your environment, know where your hazards are, and this is, so if you know that you're in front of a judge who just doesn't take any mistakes, or you're in front of a judge who you can tell a joke in front of, or a judge who's serious, know these things, because it'll help you navigate the courtroom, and it'll help you build a relationship on a professional level with the judge. Another point to this, if you're in general district court, of course, you know that you have an automatic right of appeal to circuit court, so you can take some risks as long as you've explained them to your client or know that they're not fatal. You've got a built-in safety blanket. If you're in circuit court, you may not be able to take those risks, because if it's not a procedural matter, it's going to be hard to get it reversed on appeal. So know your environment, know who the judges are that you're in front of, know who the attorneys are on the other side of the table from you, and it'll help you set your case and sell your case. Make all necessary motions for preservation. This is a little bit out of order, but it's another war story. In Virginia, after the plaintiff puts on their case, and this is when I was doing defense work, if you don't think they've met their burden of proof, you have to articulate in a motion to strike the plaintiff's case. You ask the judge out loud in front of the court reporter that you're moving to strike the plaintiff's case. I was in the courtroom one time on a case, and I stood up, and the judge said, "Mr. Sievers, I know what you're going to do. I'll take your motion under advisement." And I was an attorney for about 3 years. I said, "What do I do? This judge is telling me to sit down, but the Supreme Court is telling me speak up." So, and of course the jury's over here, everything's flashing around you. With all due respect, you must tell the judge, "I need to lay my motion on the record, Your Honor. I've got to do it." And because if you don't, you lose it. So if you got a judge that doesn't want to hear it, you're going to have to figure out how to make him hear it or make her hear it, or you're going to be in a real spot. So make all necessary motions for preservation, and you got to do it respectfully. So I just said, "Your Honor, I've got to do it." And he said, no, I've got to do it. So he said, "Come on up." And we made the motion, which you have to do it. Educate your client on the hazards as well. Clients, and have a hard time understanding, in my experience, the difference between the real world and the application of the law. And I just touched on this a minute ago. But a good example of that is the case I mentioned earlier where the gentleman was on foot and had alcohol in the system. Well, why can't we mention that? Because the court says we can't mention it. But I don't understand. He was drunk. The judge has said we can't mention it. And if you mention it, it's going to be a problem. Another example for any of you folks who do insurance defense or personal injury work, you cannot mention the word insurance in a courtroom, just like you can't mention the word seatbelt. So if either party mentions insurance on the stand, it is possible then that the case will be mistried. Now, I've seen it all. I've had cases where everyone says insurance and we get to the jury and it works out. I've had cases where everyone says insurance and the judge upsets the apple cart and we have to start over. Now, if you're billing somebody for that, they're going to want to know what happened. So if you tell your client, well, what happened was I told you not to say insurance and you did it anyway. So you need to let your client know the landscape. They also don't understand that a lot of times that they don't get to tell their story in one foul swoop. I've got to ask you questions. You've got to answer them. If the judge asks you questions, you've got to answer them. Let them finish their question before you begin your answer. They're so passionate. Again, remember, this is the culmination of 2 or 3 years maybe. This is their day in court. I'm not about to let some lawyer do this for me, right, if that's their personality. So you've got to calm them down. You've got to tell them what's going to happen. You've got to make sure they're ready. They need to understand the hazards of not doing what you advise them to do. Don't let your client fall asleep at the wheel, even if that's what got them in this mess in the first place. What I mean by that is this. If you're in a jury trial, these 7 people in a circuit court case, your jury is primarily 7 in the civil arena. It can be 5, and I'll tell you about that in a minute. These 7 people are just meeting you and your clients for the first time. So they're going, that's an ugly tie, or I like that haircut, whatever it is. If your client is reacting to statements in a negative way or bored, the jury could latch on to that, and no matter what you say as their advocate, it could be game over. So I always tell my clients, you wanted your 15 minutes of fame, here it is. You're on camera. The microphone is on. You are being watched. You're in the fishbowl. Whatever you got to tell them to make them understand that when they walk into that courtroom, everything they do is going to be monitored and could be the difference. And that's also when they're on the stand, of course. If the other attorney wants to beat you up, I say let them, because then that'll help you tell the jury all about why they have no case. That's why they came in here to beat my client up. So just make sure that as prepared as you are, your client needs to be equally prepared. And we tell them it's a job. You need to treat this like a job. If you want to be successful and put your best foot forward, you have to be a professional about this. And they haven't been there before. You guys have been there. They get scared. They get nervous. They don't understand. So you have to be their friend, their counselor, and then when their parent figure when necessary. Listen. A lot of people go in to the courtroom and have their case all laid out. Got my notes, I'm ready to go. And you miss every single thing the other attorney says when there's all kinds of nuggets in there, things that you can use. Ladies and gentlemen, I had a case one time where the plaintiff's attorney stood up in his opening statement said, the only reason we're here today is because they're going to call my client a liar and a fake and a cheat, and on and on and on. Well, I stood up and I said, well, ladies and gentlemen, I'm not sure what that's all about. I'm not going to call anybody a liar. I'm not going to call anybody a fake. I'm not going to call anybody a cheat. Well, I promise you, I didn't have to tell the jury much more that day, because I heard what he said, and I showed them that I wasn't going to say that, and I got instant credibility. If I'd been buried in my notes and getting ready for my opening statement, I never would have heard that. So when you go into the courtroom, your case has to be up here. It has to be, for a number of reasons. It's going to be so fluid. Things are going to come up. You can't be prepared for everything. The starting point is listen to what the other side says, because you want to take every opportunity you can to flip upside down any offerings they make or to rebut those things. So listen to what they say. Objections. there are different schools on objections. My school is this: the courtroom is not a gymnasium. In other words, I subscribe to the philosophy that you don't object unless you know you're going to win. How do you know you're going to win? You don't, but you've got some good idea based on the scenario in front of you that you're likely to win. Objection, Your Honor, not into evidence during closing arguments. He didn't say that during the trial. There was no evidence to suggest that evidence. Objection, not in evidence. You know you're going to win that objection. So some people say make objections just to sort of break up the other side's train of thought. That's not me. If that's you, that's fine. I have no objection to that. That's just not how I operate. So you're going to have to inject your own personality into this. But I tell you what, one time I had a case where the attorney in the opening statements was going on and on and on about things that were not relevant, and they were somewhat argumentative. And I thought to myself, I can object to this and get this back on track, or I can let him go because I can see, and this goes back to knowing your judges. I know this judge, and I know what he's about to do. He's about to hammer this guy for arguing outside of the lanes. And when the judge does it, and I don't have to object to it, it's instant credibility for me, or instant non-credibility, or however you say it, for him or her, right? So if that happens to you, think it through. You'll have time, and react accordingly. It's always better for a judge to hammer somebody than it is for you to object and do it that way. So I object as little as possible, but I always object when I have to. I think it gets overused. That's my personal thought. And that leads me to sort of whatever strategy works best for you is what works best. You all have your own personality. You all know how to sell your case. And you have different styles. Don't be afraid of those styles. The jury needs to see that you're not a robot. The jury needs to see that you're a person too. And the only way to do that is to be yourself. You don't want to go, and I'm going to get to this in a minute, but you don't want to go in there reading a script. You want to go in there and just talk to the jury. And to that point, I'm going to say brevity, 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 brevity. And the irony there is a lot of lawyers want to get in the courtroom and talk for no reason other than they think that if they don't, they're going to leave something out, or they're not going to do all they could have. If you know your case well enough, you can go in there and say it quickly, succinctly, and thoroughly, and sit down. And that's not to say that if you have a huge 3-week jury trial, you can do what you need to do in 5 minutes. But it's to say that people are afraid of silence a lot of times. You'll see witnesses on the stand who will just ramble on because the other attorney stands there like this. That's not an invitation to keep talking. That's an invitation to wait to the next question. It's the same for us. You can get your point across in such a way that you don't have to ramble on and on and on. It's better, I think, at least. So you've put your trial on, which obviously, you know, if you're the plaintiff, you open your case. You put your case on first, your case in chief. If you survive a motion to strike, if one's made, the defense calls their witnesses. Then if you have any rebuttal witnesses, you can offer them. But let's say now that we are to the jury, and the jury comes back and awards some amount. Now, this is specific to the personal injury insurance defense landscape. If you're on the defense side of this coin, what happens is if the plaintiff wins, a judgment will be entered against your client in their personal name, okay? So it's very important, if the court will let you do this, to ask that they not enter judgment for a period of 2 weeks. Now, the other attorney may agree with that. The other attorney may disagree with that. But here's why you do this, and I'll tell you a story. I had a client one time who I asked, could we not enter judgment for a period of 2 weeks? And the other attorney said no, and the court said, we don't do this in our courtroom. If you want me to have a jury hear your case, you're going to get a judgment entered against your client. Some judges will allow it. Well, that's fine. What happens is when you pay the judgment, they're supposed to send a letter into the court that says judgment is satisfied. Please mark it satisfied. So that when a creditor comes in to look for you for your home loan or something, they can see you've had a judgment against you. It's been marked paid. Well, in this particular case, the letter got lost in the mail. The court didn't mark it down. I get a call from a client 3 years later. I'm trying to buy a house. They're telling me there's a judgment entered against me. What's going on? I don't remember you, excuse me. Panic time, right? So if you're on the defense side of this thing, that's a maneuver that you can do that usually is permissible that will save you a headache down the line potentially. And most plaintiffs' attorneys don't have a problem with it. If they do, it's their prerogative, but I don't know why they would. Before I sort of move on to each court at a tier, I would say this. Jury trials can be nerve-wracking and tiring, but they can also be a lot of fun. If you're into that sort of thing, they can be a lot of fun. You know, have fun in there. You can tell a judge a joke. You can tell the jury a joke. It doesn't have to be, out of a book. It needs to be organic and sound sincere, but I always try to open up with something funny. I had a jury trial 2 days ago. I could barely talk. My voice was gone. I told the jury, you might want to sit in the back row because I'm going to be coughing all over you. I mean, that's kind of stupid, but it breaks the monotony of it. And some of them laughed. Some of them didn't think it was funny, but whatever. I mean, the point is you can do those sorts of things and be human about it. Now, I just want to move to the General District Court for you briefly. Of course, you all know that matters in controversy of $25,000 or less. It used to be $15,000. They upped that 3 or 4 years ago. There's very limited discovery. In other words, you don't exchange interrogatories. You can subpoena some records if you'd like. The point of it is obviously to try a case in a limited scale with limited expense so that if either side doesn't like the verdict, you can appeal it automatically to the circuit court. And there doesn't have to be a reason. You just do it. You have 10 days to note your appeal, and you have 30 days to post your appeal bond. If you're on the defense side of the case, you usually have to pay the judgment amount plus something additionally. If you're on the plaintiff's side, I think it's like $138. Whatever it is, the court will tell you. You just want to make sure that if you're appealing from GDC, you follow the correct procedures so you don't lose your right. It is a great place, of course, to get your feet wet if you want to look at it that way. You'll meet some judges, you'll make some mistakes, you'll get yelled at, but you'll have a good time and you'll experience the courtroom. It really is a good place to get your feet wet. The circuit court is matters in controversy of $25,000 or more. You can have a bench trial or a jury trial, and General District Court is bench trial only. Circuit court, I would say typically, unless it's a complex business case, having a jury is always better. It's really amazing to me how 7 people who don't know each other and have never met can come together and get it right. 9 times out of 10 they do. That's been my experience. And if they get it wrong, there are measures in place to set aside the verdict. So my personal opinion is jury always. I leave that up to you as the attorneys, but that's your option. If a case in circuit court, and I may not have the numbers right, it used to be if it's less than $15,000, you could actually have a jury of, and you appeal it to circuit court, you could actually have a jury of 5. Now that number may have changed when they upped the cap of circuit court to $25,000, but I have had that happen to me before. The judge will usually ask you, do you want 5 or do you want 7? There's no right or wrong. It's just how do you feel about it? Of course, if you have 7, you have more people. If you think your case is shaky, maybe you want more people. I don't know, but in any event, the options are there. The voir dire process, okay, guys, this is important. In the civil arena, you're going to have, maybe 30 potential jurors in the courtroom. They're going to randomly select 13 of them to come sit up at the bench. When they get up there, you're going to select 7. Each side can strike 3. So this is your first introduction to these people. And you can't really get away with joke telling at that stage, but you can sort of let them know that you're appreciative of their time and their energy. You want to ask questions that guide them to where you want your case to go. Obviously, if it's a personal injury case and someone's had a back injury and someone says, if you've had a back injury, I don't like you, I want you off my jury. If you're the defendant, you want me on your jury. Ultimately, we're going to select 7 jurors to sit in on your case. Is that clock right? All right, just a few more minutes, sorry. So, very important, voir dire. It might be the most critical thing you do. It's also the scariest thing you do. It's also the thing that no one knows how to do right. Because if you did, you'd be making a lot of money and you wouldn't be working for a law firm. You'd be writing books on how to pick the perfect jury. So really, you do the best you can. There are certain tells, obviously, depending upon what your case is, that might help you. But those are all sort of things that crop up as the case comes along. Closing argument, obviously, it's still okay to be funny. I think the jury wants to hear from you that you're a person. You don't need to be robotic again. Maybe in a criminal case, that's not the best thing to do, but in a civil case, certainly being funny at the appropriate times makes sense. I just want to jump through a few of these real-world practice tips real quick. I've laid them out for you on paper. I'm just going to pick a few. Old dogs can teach new dogs tricks. That's probably the most important one. Find a mentor. Don't lose an opportunity to pick someone else's brain. No one is too old to not have a mentor. Find them. Find a retired judge. Find a lawyer. They don't have to work with you or for you. Introduce yourself. Buy them a cup of coffee. Buy them lunch. Whatever it is, pick their brain. The only question you can ask, I mean, there's no such thing as a dumb question except for the one you don't ask. I'm a firm believer in that. Find a mentor. Ask them questions. Learn from these people. It will help you along the way. You guys are probably too young to remember Voltron, but that was my example the last time I did this. Join forces whenever you can. 5 is better than 1. Nobody knows the ins and outs of this stuff to a T. In the practice of law, unique things pop up all the time. You need to be able to press that red button on your phone. Hey, I got a question any time of day, any time of night. Join forces whenever you can. Rely on your colleagues. Don't reinvent the wheel. Obviously, no point in drafting your own complaint if you've got a buddy or a colleague that's already done it. Pick people's brains. Learn how to navigate the waters without putting in extra work. Another important one is it's easier to ask for permission than forgiveness, and I say with the exception of the Virginia State Bar. So they have an ethics hotline. I've listed the number in here. I've used it myself. They will talk to you anonymously. You can be candid with them. You can tell them exactly what's going on in your case without violating any client confidentiality, and they will let you understand what their opinion is likely to be. There are also published opinions that LEOs that are on the website that will help navigate you through some issues. A couple more real quick. Appreciate, respect, and recognize your office team. I mean, you guys you're out in the courtroom, but I tell you what, your staff has done a lot of hard work to get you there, and they know the clerks, and they know the judge's assistants, and they can make or break you. So you're a team. That's how I've always viewed it. I may be the one in the courtroom, but I wouldn't be there without everyone who's behind the curtain. So you see a lot of lawyers who just step on their staff and beat them up. Bad idea. We're all one big team as I see it, and everyone is just as important as the other. Spring cleaning doesn't apply to your contacts list. It goes back to what I said earlier. If you met a buddy in college, you both got out of the fraternity, and wow, I'm a lawyer, wow, I'm a doctor, I can't believe it. You might need to circle back and call him. Don't throw away business cards. Don't throw away what you've got in your iPhone. Keep that stuff. It's important. You might need it later. Lastly, just sort of generally, I think you all should participate in a couple of programs. The Virginia Supreme Court has what's called a new judge training program, and I've done this a bunch, and I really think you should do it for a couple reasons. It's very helpful. The bar is very appreciative of this. There aren't a lot of volunteers. But whenever there's a new circuit court or general district court judge appointed, they bring them to Richmond for a couple days of training or however long it is, and they do mock trials. You can pick circuit court or general district court, and you get CLE credit for it. It's the same case every year. Some guy steps off a train, slips on a platform that's covered in snow. But what they want you to do is try the case in front of the judge. The neat thing is they script it, so they want you to do things like yell at the judge or sit down, go hop up on the bench and pat the judge. I mean, it's fun, right? Because you get to screw with the judge. But you get to try a case free from the realities of an actual verdict. The Supreme Court appreciates it. The bar appreciates it. The judges appreciate it. And you have just tried a case without any real pressure. So I would strongly suggest that you sign up for that. The last one is law school moot court competitions. Now you're on the flip side of these. Find one where you are and judge it. That's a great way for you to learn a new area of the law maybe, but it's also a great way for you to continue your education in that sense and to meet professors at law schools who then may be breeding products that you want to hire. I mean, there's all sorts of possibilities from that. So I would suggest moot court competitions, if at all possible, and the high school level too. And there's some good ones at the high school level that you can participate in. Quickly and lastly, judges are people too. You see them out on the street, don't be afraid to go up to them and say, hello, I'm so-and-so. My last name, for whatever reason, no one can pronounce it, Sievers, but when I'm in the courtroom, I always say, Judge, it's Rob Sievers, nice to see you again. That way they won't stand up and say, this is Mr. So-and-so, and you'll have to correct them in front of the jury. But they're people too, they make mistakes, they're good-hearted, they'll talk to you. Just because they're on the bench doesn't mean they can't provide you with some advice if you see them out on the sidewalk. Don't be afraid of them. They are your adversaries, or advocates as well. The last thing I want to tell you is you are attorneys and counselors at law. Most people forget the last part. And it's always been impressed upon me that the last part is the most important part. A lot of your clients are coming to you and they want advice, they want help, they don't understand. You have to counsel them. You're not just their attorney. I know I brushed through those last ones pretty quick. I'll be here the rest of the day if you have any questions. Does anybody have any questions now? Yeah. So you have to have a really big case, I think, to justify that expense. And I've never been involved in that process, so I wouldn't stand up here and say that it's not helpful. But as I think I can say confidently that nobody knows how to pick a jury any better than anyone else, or they would be doing it. So if you have a big enough case that justifies the expense, mock trials are usually what you see. But again, that's those 7 people versus a different group of 7 people. I tried a case 2 days ago for the 3rd time. One jury gave $14,000, one jury gave $400, and one jury gave $11,000. So you don't know, right? So I defer to you on that. I really don't have a thought. Well, I guess I don't usually do the knock-knock jokes or the why'd the chicken cross the road. I usually just sort of try to say something that's funny, like one time I had a jury that was made up of 7 women, and I started to stand up and say, ladies and gentlemen, and I said, ladies. I mean, it's not really a joke, but it sort of lightens the mood because both the other attorney and I, you go into that robot mode and you want to say ladies and gentlemen of the jury, but we had selected a jury that was all ladies, and I have never had an all-lady jury since or an all-male jury ever. So stuff like that, just little, it's not really a joke, but it's just a sort of a soft introduction to let them know that you're not just an attorney. Well, I appreciate it, guys. I'll be here if you have any questions later. Thank you.